31st January 2023. What reel I am making is a very important judgment of 2020 passed by the Supreme Court. Now, I have come across this judgment recently, and so I found it very important for my viewers, those who see my reels regularly, and for them I am making this reel. The party's name is Abhilasha versus Prakash. The issue here was petition was filed by under section 482 of CrPC by the appellant for setting aside the order of the judicial first class magistrate of Rewari passed in 2011, and also order dated of 2014 passed by additional sessions judge Rewari. The issue here was the daughter of the appellant is not a minor, and two sons and the appellant daughter along with her filed for maintenance under section 125 of CrPC against the husband, that is Prakash, claiming maintenance for herself and her 3 children. Now the learned magistrate while its judgment disallowed the maintenance and dismissed the application under section 125 of the CrPC. Why it is very important? See, before even if your lawyer advises you to file under 125, and if you are a Hindu and your daughter is going to attain majority, then please check the jurisdiction of the court and file, because as per this judgment of the Supreme Court, the magistrate has no power to grant maintenance under section 125 of the CrPC to a dependent major daughter. If a daughter has attained majority, then he has no power to grant maintenance under section 125. However, if you are a Hindu, then under section 20 of the Hindu Act, Hindu laws, you are entitled to demand maintenance for a dependent major daughter who, even without disability, under section 125 of CrPC, if you are a Hindu and your daughter is suffering from disability, magistrate has power, but not in any other case. So in this matter, the Supreme Court directed that accepting the submission of the learned counsel for the appellant, that as a proposition of law, an unmarried daughter can claim maintenance from her father till she is married, relying on section 20 subsection 3 of Hindu Act of 1950, Hindu law of 1956, provided she pleads and proves that she is unable to maintain herself, for enforcement of which right her application and suit has to be heard under section 20 of the Act of 1956. Now here, if you file maintenance for application for maintenance in family court, then family court has jurisdiction to grant maintenance to dependent major daughter, but not the criminal court under section 125 of the CrPC. So in this case, the court directed and granted liberty to the wife, that is the appellant, to take recourse of section 20 subsection 3 of the Hindu law of 1956, and if advised, it was Supreme Court was kind enough and said that in fact of the present case, to meet the ends of justice be served by giving liberty to the appellant to take recourse to section 20 subsection 3 of the Hindu law of 1956, if so advised, for claiming maintenance against her father. Subject to liberty, the appeal was dismissed. So even when you go to a lawyer, you should have this much of background that whether it is right or not, or whether you are advised properly. Of course, all lawyers are good, and it is not that they misguide, but then sometimes it so happened that it turns out to be something. Because I remember Justice Chagla had said in his book also, it is written that sometimes we don't know, because one of the lawyer was arguing rationing act, and he said that any such act is there in force. So he said that even judges sometimes are not aware, and it is advocate who argue at that time they come to know. It is there in his wonderful book Roses in December by Justice Chagla. Do read.